What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta, owner of Rekieta Law, a small law firm in central Minnesota, and I am here today to discuss some new documents in the ongoing lawsuit between Dick Masterson and Maddox, among other people as well, of course. Don't let me short sell anyone who has been roped and sucked into this black hole of a lawsuit. So, today we have a little present, and let's get a yeah. I'm going to leave the yang to Dick. Also, I'm mildly ill, so I'm not going to do that today. But maybe when we get done with this entire lawsuit and we can get everybody together, we can get one giant synchronized yeah among everybody, or something ridiculous. Let's cover a couple ground rules, quick housekeeping, and all of that good stuff that comes at the beginning of every one of these live streams. First things first, we have a pre-game super chat from Adam Smith, who is having a family dinner and festivities for his birthday. Happy birthday, Adam. And he won't be viewing tonight, but he hopes for good things. God bless Rackets. So thank you very much, Adam. I really appreciate that. And I hope you have a good time with your festivities. Hopefully you'll get to listen to this later and enjoy that. And there goes the internet. That's terrific. It's coming back, though. It's coming back. Lucifer Love Monkey says, tonight's stream is funded in part by Iron Maiden and viewers like you. Wait, let me give that my advertising voice. Tonight's stream is funded in part by Iron Maiden and viewers like you. So, okay. Sorry about that. So quick housekeeping. Quick housekeeping is, as we've been doing lately, the live stream format is modified slightly where I will not be interacting with the chat except for super chats during the reading of the document. This document is 18 pages. It should go pretty quickly compared to some of the other ones. There are no additional exhibits or anything to go through. Tillip says, Alexa, order 4,500 live ladybugs overnight. Okay. Thank goodness Alexa's in the other room. But I'm sure she can hear me because Jeff Bezos is a terrifying human being. So as before, I will react to super chats, but we're going to try and plow through the document for the people who are listening later. The format seems to work out well, and it allows me to focus a little bit more on the document itself, and that's a good thing. That's a good thing. So we'll implement that rule in just a moment. And then, of course, after the document is done, there will be some Q&A time where I will take questions on, the document or anything else. So if you do not want to do a super chat, and I can fully understand that, save your questions, write them down, ask them later, and I will try and get back to that. Excuse me. Like I said, I'm mildly ill. The next piece of important information to cover is it is apparently International Whiskey Day. So I hope you all have your whiskey. And I will be grabbing from the cabinet back here. As you can see, I have rearranged my desk. And that is not to give you the illusion that this room has been cleaned in any way. It's likely more of a disaster than when you last saw it. But this allows me to lie to you in proper lawyer fashion. Bear Lou says, 6 a.m. commute to law school plus Nick equals not even mad. Thanks, buddy. I'm not mad either. So tonight I will be drinking the Balmore Darkest 15-year. Again, if you have not had this whiskey, strong recommend on it. It is very, very good. It is reasonably priced. It is very smooth for the, especially given the price. Let's see. I don't know I mean, leaf whiskey does count. It is International Whiskey Day. So no matter where your whiskey is from, you qualify today only. Today only. Yes, and drink your gin martini and then go for scotch. All right, guys, I'm going to no longer interact with the chat. We will be implementing the plow through the document, you dummy rule, and we will get moving. Get on with this whole show. Get on with this whole show. I'm hoping not to keep you guys for like 10 hours tonight unless you want me to. Actually, please don't. Garrett Davis says, first time making a live stream. Cheers, Rackets. Toast Dalwhinnie 15 year. Buddy, Dalwhinnie 15 year is one of my favorite scotches. So enjoy it. That is delicious. All right, so the first thing I have, this is just a gem from Twitter. This is from RD. It says, lol, this reads like a law prof's red line notes to a first year's very first civ profiling. And if you'll notice, I have cited RD in proper Blue Book Twitter citation format. And thank you to David Ziff for helping me out with the Blue Book Twitter format. That is especially heartening to me, you know, that even exists. So Blue Book is a terrible, terrible thing, although it is extremely useful, and having a Blue Book for Twitter makes me happy. All right, so that's just a little bit of fun, and now let's get into this response. So this is Michael Munoz's response to Kevin Landau. Kevin Flesher says, whose idea was it to make International Whiskey Day on a Tuesday night? Got work at 4 a.m. Can't be too hungover. Thank you, Nick Rackets. Well, thank you, Kevin. And definitely don't get too hungover if you have 4 a.m. work. And I will try and keep this stream to a reasonable pace for you. I don't know whose idea it was. I'm sure someone who sells whiskey. So this is just a brief rundown on where we are in this motion. This is motion sequence number 4. So this is Weber Shandwick filed a motion to dismiss all of the claims against Weber Shandwick and Joshua Kaufman. And then, of course, Kevin Landau went ahead and opposed that motion to dismiss, as his job is to do. And then this is Weber Shandwick's response to the opposition to the motion. Adam D says, a lawsuit is like an involuntary poker game. Plaintiff throws down a bet, and you can't turn away, only play, but bet, but if your opponent is better funded, he can force you to go all in or fold, settle. That is actually a very good description of how lawsuits work. The plaintiff holds a lot of the cards. Unfortunately, that's just the way it goes. It's just the way it goes. So, this is the reply memorandum of law in further support of the motion by defendants CMGRP, which is a parent company of Weber Shandwick, and Joshua Kaufman, to dismiss all claims asserted against them. And let's get into it. There's a table of contents that says all of this is wrong and stupid. We're going to skip that and get right into the introduction here. Defendants CMGRP Incorporated, doing business as Weber Shandwick, and Joshua Kaufman respectfully submit this reply memorandum of law in further support of their motion, the motion, pursuant to New York Civil Practice Law and Rules 3211A, 1 and 7, to dismiss the complaint filed by plaintiffs George Orangutan, professionally known as Consistent Loser, and Jane Doe, now identified as Jessica Irene Blum, collectively the plaintiffs, as to those causes of action asserted against Weber Shandwick and Kaufman. So their motion is limited only to the causes of action asserted against Weber Shandwick and Kaufman. And this is a good time to mention that if any one of these individual dismissals goes through and the other dismissals do not, that the claims are not dismissed against any of the other parties. So, I mean, they could be, but this motion is to dismiss only the claims against Weber, Shandwick, and Kaufman. So assuming that, like, Patreon's motion prevails and maybe Asterios's doesn't, then Patreon's claims are dismissed and Patreon goes home and is ignored forever. And Asterios would then still have to go ahead and proceed with the action until he is able to prevail on his claims or lose on his claims. Hopefully not. And this is a good time to note or to mention patreon.com/Asterios. Support the man who is unfairly roped into a prior restraint on First Amendment rights. Okay, that's what this case boils down to, right? It's the right to say things and not, and sometimes those things are offensive, sometimes those things are uncomfortable, but as long as they're not false statements of fact that cause damage, and as long as they're not direct, imminent threats of harm, then they can be said. And they may hurt feelings, and we should protect the right to do that, because some people need their feelings hurt. All right. So the preliminary statement. Plaintiffs commenced this action against Weber, Shandwick, and Kaufman by filing a complaint consisting mostly of bare, not some might say bald, conclusions of law, and devoid of factual allegations to support their claims. They seek to impose upon Weber, Shandwick, and Kaufman purported duties that exist nowhere in the law and assert injuries that could not have been caused by Weber, Shandwick, and Kaufman except in the most theoretical sense. Plaintiff's opposition to the motion merely repeats the complaint's deficient allegations, mischaracterizes arguments, and cites to case law that is entirely distinguishable, and often that underscores the complaint's lack of merit. The opposition utterly fails to cure the complaint's glaring defects. So Weber Shandwick's lawyer Munoz has come out swinging on this, letting the court know exactly what the opinion of their firm is. And the opinion is pretty consistent. Landau's complaint, his opposition, they're not well researched. They have deficiencies in their factual allegations. They mischaracterize arguments. I would say they mischaracterize many facts. He's talking that they cite to case law that is entirely distinguishable. So as a note, what they're talking about there is when they have a citation to an existing case, you have a couple different things that you have to do. What you have to do as the opposing party is to show why that case is not like the current case. So that would be entirely distinguishable. So if it's partially distinguishable, you show how it's partially distinguishable on the relevant facts. If you say it's entirely distinguishable, you're saying that this case has no bearing and shouldn't even be considered, and citing it is actually incorrect. So it's pretty strong wording coming out in this preliminary statement. There are two new developments arising from the opposition. The first is plaintiff Orangutan's admission that he lied to Weber, Shandwick, and Kaufman by sending them multiple emails in which he pretended to be a journalist working on an article about internet harassment, criticizing a Weber, Shandwick employee, defendant Asterios Kokkinos. Those deceptive emails are the foundation of plaintiff's claim, and that Weber, Shandwick, and Kaufman owed some kind of duty to protect them from Kokkinos' alleged personal activity on the internet. And there is a footnote here. It says capitalized terms not defined herein shall have the meanings ascribed to them in Weber, Shandwick, and Kaufman's memorandum of law in support of their motion to dismiss, dated January 10th, 2018. Plaintiff's memorandum in opposition to Weber, Shandwick, and Kaufman's motion to dismiss is referred to herein as the OPP. Yeah, you know me. Plaintiff's continued deceit in using those emails in their complaint and their attorney's refusal to rectify that deceit will be addressed in a cross motion for sanctions to be filed shortly. And that is ominous, my friends, because what they have done is continually lied to the court. They've continually lied to the parties. And what's interesting about all this is that if you'll notice from Landau's letter and Landau's motion to the court, he's trying to skirt this line where he's implying that Weber, Shandwick knew that Heather was Maddox and informed Kokkinos that it was Maddox. He doesn't say that. He doesn't say that, but he implies that. And we all know how we feel about lying and implying, right? But he implies, based on Asterios' tweets demanding that Maddox go ahead and demanding that Maddox apologize for contacting his employer. He's trying to imply, in a way that the court will not enjoy, the idea that Weber Shandwick knew that Heather was George, which how would they know? Because Weber Shandwick doesn't care about Maddox. No one cares about Maddox, and certainly not Weber Shandwick. These are normal people, not like us. And they don't have time for an internet idiot, right? They just don't. So they don't care. They don't know who he is. They just tell Asterios, hey, some lady named Heather is writing this. They may have said, we're not quite sure if this is actually a real person or whatever. We have reason to believe, mainly because they misspelled their own company's name in their signature line, that this might not be the person. But, you know, here you go. Here's this information for you, Asterios. And then Asterios correctly presumes that it's Maddox. Okay? Landau is trying to tread this line in his motions to imply that Weber Shandwick knew and that Asterios knew, and therefore it's not a secret even though he's lying to the court. So he's again lying to the court to try and cover up the lie to the court. Very good. Very good. Good job. All right, so then here we have a footnote for that. In short, Azunian created a fake persona, Heather, supposedly a journalist at Condé Nast, and I would say he did not create Heather. I would say he appropriated Heather, who is Heather S. If you go watch my previous live stream, you can dox her LinkedIn profile because they linked it in the document. But I find the fact that he picked Heather S., who is there, and having there actually be a Heather S., who is a content creator for Condé Nast, to be a little too coincidental. I'm pretty sure Maddox, in his expert researching skills, found someone and then assumed their identity. But Weber Shandwick doesn't go that far in this document. We'll see what they say. We'll see what they say when they come out with their motion for sanctions. Okay. Supposedly a journalist at Condé Nast who contacted Weber Shandwick on the false premise that she was writing an article about online bullying and harassment. She then claimed that Kokkinos engaged in harassment, although the alleged supporting information that she provided to Weber Shandwick did not reference any actionable statements made by Kokkinos, but rather by defendant Herrera. Azunian admitted his deception in an affidavit filed in the opposition to this motion. See Landau Affidavit Exhibit 3. So again, even in this footnote, Weber Shandwick is making a defense for what's going on by saying that, look, provided us this information, but even this information was not actually actionable against Asterios. It would be actionable potentially against Masterson. And the reason they're saying it'd be actionable is because the words that they used to try and that Maddox used to try and get Asterios in trouble actually were attributed to other people, including Dick. All right. Getting on with it. The opposition also includes an affidavit from non-party and barely person Jesse Powell Stroud, alleging that Powell Stroud discussed Kokkinos' alleged harassment of him, not plaintiffs, with Kaufman prior to Weber Shandwick's receipt of Azunian's deceptive emails. Powell Stroud is a business associate of Azunian, something not disclosed. Oh, as they say in the parenthetical, a fact that he does not disclose to the court. And that does matter. Right? Because let's say you're the boss of a company, of a small business, and then all of your supporting witnesses happen to be your employees or associates. Their income is tied to you in some way. We'll say employees. So that when you are a random bootlick to someone else, and that someone else has you as their rabid little attack dog going after people, you need to disclose that relationship to the court. Because if you don't, and it comes out from the opposition, it just looks bad. Like, oh, look, this person with a business interest in finding the plaintiff correct says the plaintiff is correct and suddenly is in support of him. Sometimes I wish I had sound effects. Footnote again. Powell Stroud regularly appears on videos posted on Madcast Media. Plaintiff Azunian Azunian's media platform. See Powell Stroud, Do Video Games Make You Gay? March 8th, 2018. Powell Stroud recently hosting video on Madcast Media. And complaint, paragraph 99, identifying Madcast Media as Azunian's platform. So there we go. And make no mistake, guys. they picked this specific title of the video for a reason. You know, it's just one more little jab. One more little jab. And there is no explanation as to why this affidavit suddenly surfaced in opposition to the motion. And the reason there's no explanation, or the reason that they're calling into question the lack of explanation, is that you can't introduce new evidence into a opposition to a motion to dismiss. You can't do that, except under extremely limited circumstances of the rules. In this case, this affidavit has nothing to do with those rules. Those rules would be like for jurisdictional purposes, where you suggest that you've got new information about jurisdiction that says that the court has authority that you didn't have access to before, something like that. They had access to this. They had access to Jesse Powell Stroud long before this claim was filed. They certainly, obviously, he allegedly contacted Weber Shandwick before Maddox, so they had access to all of this long before the action was filed, and not filing it initially means it shouldn't even be considered now. Shouldn't even be considered now. All right. But in all events, the bare bones affidavit contains no allegations establishing that Weber, Shandwick, or Kaufman owed any duty to the plaintiffs or took any action giving rise to cognizable claims. Right? And it doesn't. It doesn't. It was a weird gamble that they threw in there. Or like, not a gamble, but a weird sort of Hail Mary. Plaintiffs' claims remain as woefully defective as they were on the day the complaint was filed, and plaintiffs' arguments in opposition to the motion fall well short of saving the deficient pleading. Accordingly, the motion should be granted in full. All right. Argument. All of the claims against Weber, Shandwick, and Kaufman must be dismissed for failure to allege negligence as a matter of law. The complaint asserts claims against Weber, Shandwick, and Kaufman for negligent hiring and or retention, negligent supervision, negligence, and negligent infliction of emotional distress. For the reasons discussed in our initial memorandum and more fully set forth herein, each of these claims must be dismissed because the complaint does not adequately allege that Weber, Shandwick, or Kaufman 1. Owed a duty of care to plaintiffs, 2. Acted without reasonable care, or 3. Proximately caused plaintiffs' alleged injuries. Those are the 3 elements of negligence. Jacob Cerizia says, will a judge just find one reason to dismiss, or will he go over all of the motions? Still sending Japanese whiskey, getting married soon, so money there first. Yeah, Jacob, thank you very much for that. And you know, I'm happy to receive Japanese whiskey, but certainly put your money where it is most important. I really appreciate the donations, and good luck on the wedding. They're fun, expensive, and sort of crazy affairs. Okay, so a judge finding one reason to dismiss per claim is sufficient. If there is a reason to dismiss, they will go through. Now, to answer your question, what I think you're asking is, let's say a judge finds one immediate reason to dismiss, and it's the first argument that's presented. Will they go through the rest? Yes. They will go through the rest because they have to set a record where, in case this were appealed, that each of the claims is addressed fully. Because if they dismiss on one ground and then not address any of the others, and then it's appealed and they overturn that one ground on appeal, then you've got all the other grounds to go through. So the judge should be going through every single thing. Now, it is... yeah, I mean, that's the basic answer to the question. That's what will likely happen in this case. So we should throw up a quick prayer for Ramos for having to go through all of this, because the man is going to be swamped reading documents that have taken me, several hours to go through. He will be going through them, and or his clerks will, one of the two. and really giving them even more attention and having to cross-reference all of the citations and making sure they're cited correctly and all that stuff. So, plaintiffs' arguments on these points are unavailing. Plaintiffs assert that the complaint states claims for negligence by alleging that Weber, Shandwick, and Kaufman knew or should have known of Kokonos' allegedly wrongful actions sometime in February 2017 when Heather, who we now know is actually George, contacted Weber, Shandwick, and Kaufman and asserted that Kokonos participated in harassment against unnamed individuals on the internet. Plaintiffs also submit the affidavit by non-party Powell Stroud, in which Powell Stroud asserts that he had a telephone conversation with Kaufman regarding Kokonos, but does not provide any specific facts concerning the conversation or any explanation of what the parties actually discussed. And it's interesting, if you have not seen it, to go and read his random apologetics that were in some thread, and someone will know what this thread is on Reddit, where he details his histrionic personality, in which he suggests that Weber Shandwick was immediately prepared to fire Asterios Kokonos, but he decided not to pull the trigger. In all of his benevolence, he just wanted Asterios to know that that he was in danger. Because, again, Weber Shandwick makes their hiring and firing decisions based on an anonymous internet troll's phone call, one 20-minute phone call over their senior copy editor, without contacting him or asking him. All they want is some emails that could be entirely fictitious or not. Who knows? But all they want is the word of this internet personality, and that is the hiring and firing decision that they'll make, ignoring all the potential legal implications of that. And that's just how the Madcast Media crew seems to understand things on a consistent basis. All right. Okay, and then footnote 4. The new affidavit claims that on or about February 3rd, 2017, Powell Stroud had a 20-minute telephone conversation with Kaufman regarding Kokonos. However, the affidavit is devoid of any specific facts concerning the conversation or any explanation of what the parties actually discussed. Notably, the affidavit does not even identify the alleged actions that Kokonos had engaged in against Powell Stroud, which he allegedly conveyed to Kaufman. Maybe because it's a lie. The lies. Or maybe it's not a lie. Maybe it's just a simple misunderstanding of what is and isn't illegal. So Hyperion 9997 asks, does the fact that Lauren Baker and Maddox weren't served automatically mean they don't have to participate? At this point, yes. There's a 120-day window from the time of filing the action in New York to effecting proper service. And if you do not serve the parties appropriately, it is dismissed as to those parties. So they are off the hook. They do not have to participate in any sort of way. That's the way it goes. You can't just file a lawsuit and have it sit out over someone's head forever until you decide to act. So that's how that works. Okay, plaintiff, simple rehashing of defective allegations in the complaint, which he has done in every single motion. All of his motions are terrible. Even coupled with the bare bones Powell Stroud affidavit does not cure the complaint's deficiencies. The complaint does not allege any duty owed to plaintiffs. So, here we go. Just as a legal refresher, negligence involves a 4-part test: duty, breach, damages, and redressability. So you have to have a duty of care to a plaintiff. You have to breach that duty of care. That breach has to lead to damages, and those damages have to be rectifiable by the court. Typically, we look at that as money. But, if you breach a duty of care, like if you're caretaking someone and you have a duty to, make them enjoy what they're doing, for example, and you breach that duty and they're unhappy, or just mad or in a bad mood for a day, that's not redressable by the court. Even so, you have the first 3 parts of the test: duty, breach, damage resulting from the breach, but that damage isn't redressable by the court. So that 4-part test is important. Kyle Kincaid asks, is there a strategic reason that none of the defendant counsel mentions that a Heather S. does, in fact, work at Condé Nast? Actually, Greenberger did mention that in his cross motion for sanctions. It's in a footnote. He mentions that there is a Heather S., and he links the LinkedIn profile showing Heather S. If you go back, I briefly mention that in the last live stream. So you can see it there. Greenberger does. I think Weber Shandwick might mention that more when they lay out their sanction motions. But they probably want to review all the documents and have everything straight. And I'm guessing they've been working on this particular document for a little bit and just want to get their opposition out, and they'll put the sanction motion, they'll put more information into it. That's my guess. They also don't need a Heather S. under the statute. They simply need someone representing themselves as working at Condé Nast, even without the identity of Heather S., so they may just be relying on that. Okay. Hope that answers your question. Corey Jamnick asks, does it reflect badly on plaintiff in the eyes of the court that two of the people named were never even served? Does that make it seem more frivolous? I would say it depends on the factual scenario. And in this case, I would say yes. Not a lot. This is not going to be a deal breaker for the court. But, if they're hovering on the fence on the frivolity of all this, and it comes out that, they failed to serve two people. We don't even have evidence that they tried to serve them. It's not like they tried and failed at serving. They just didn't do it. They seem to name a bunch of people that don't belong in the suit, like Patreon, like Kaufman and Cope. Specifically, individuals from these companies don't belong in this suit. So, having Maddox and having Baker named in the suit and not served might lend a little bit to the argument, but we're not talking about much influence there, just a tiny bit. Gats, can the judge order Landwy to have a breath machine attached to his computer? He should have to blow into an intoxilizer right before delivering oral argument. Or they should just have a bailiff stand in front of him and do a field test based on his breath. Raging Hot Truth says, is there any limit to how often this thing can get postponed? There's a limit to how often the parties can postpone it. Courts do what they want, man. And it sucks. Trust me. When you're scheduling things out like 2, 3 weeks, 4 weeks ahead of time, you get to that time and they're like, oh, yeah, by the way, sorry, we have 12 other cases that day and yours is getting pushed. What do you have in 3 months? It's really awful. It's hard on the clients, but there's not much you can do about it. And no, there's not really any limit. But I don't think we'll see a lot more postponement. Judges don't like to do that. They want to get this stuff done. Brief point, no one wants to be in court. The attorneys don't want to be there. The clients don't want to be there. The juries don't want to be there. The judges don't want to be there. The clerks don't want to be there. No one wants to be there. Everybody wants to get paid and go home and stay out of court because court is a disaster. Everybody's recorded. Everything gets scrutinized by a bunch of idiots like me, right? Or they get scrutinized by an appeal process, and every word could hinge on something. No one wants to be there. So they don't want to keep postponing this. They want to get it done. The longer this drags on, the more likely it is that Landau comes crying and slapping for more sanctions, and they don't want to deal with that either. Yes, let's see. So, all right, back to this. Where are we? Gatscat says, can Maddox sue the judge for postponing his windfall? He should try. That would be great. And Vistus, thank you for finding the Jesse PS thread, Reddit. Yes, it was in the AMA for the guy who wrote the book about how Hulk Hogan sued Gawker and then doesn't seem to care to look into this lawsuit, even though he spent a lot of time looking into that one and may have some biased reasons for that. Kevin Flesher, 50 words or less. How would you change the legal system? How would you change the legal system? Every change that I would make would put me out of a job. Long and short, lawyers cost too much, and they cost too much because it's far too complicated. There's too much paperwork. The barrier to entry on all of this stuff is one of not knowledge, not of fact, but of procedure. It's this weird barrier where we say, look, if you don't follow this step and this step and this step, then you're out. And there's no help for you unless you pay some guy like $300, $400 an hour to do it. And if you can't pay that guy $300, $400 an hour, then you don't get any help unless you can't pay someone anything. But if you're between the part where you can pay $0 and where you can pay, like $200, you're pretty much screwed. And yeah, Adam D brings up it's an involuntary poker game. The answer is 50 words or less. Sorry. Sorry, man. I can't do 50 words or less on that. It's a long problem, and maybe I'll do a long video on it sometime. Garrett Davis, this is to make up the exchange rates for Cat's phony Canadian Monopoly money. Thanks, buddy. I appreciate it. They have lots of color on it. Raging Hot Truth says that was 51 words. All right, guys. So we're out of the footnote and we're back into the complaint here. The complaint does not allege any duty owed to plaintiffs. Oh yes, and I covered the 4 aspects of negligence. Plaintiffs admit that there is in duty, breach, damage, redressability. Plaintiffs admit that there is no original duty owed by Weber, Shandwick, and Kaufman to plaintiffs. Okay, Pepe Frosch says, would you support a system of trial by combat? Absolutely. Corey Jamnick, could an average IQ person defend pro se? They shouldn't. And I would say a high IQ person probably, an average person defending pro se may do better than a high IQ person defending pro se, in all honesty. And there's a lot of reasons for that. And yes, Gats, your money is very colorful. And that's why it should be on board games everywhere. Okay, so there is no original duty owed to Weber, Shandwick, and Kaufman that's admitted by the plaintiffs. But the plaintiffs contend that Weber, Shandwick, and Kaufman voluntarily assumed a duty of care by, quote, answering plaintiffs' complaints, informing Kokonos of said complaints, and or failing to keep plaintiffs' identity private. Plaintiffs further claim that by virtue of Kokonos and Weber Shandwick's employer-employee relationship, Weber Shandwick and Kaufman owed plaintiffs a duty of care for purposes of negligent supervision and retention of Kokonos. Plaintiffs' arguments fail as a matter of law because the complaint does not allege any facts meeting the legal standard for voluntary assumption of duty. See the memorandum at 1619. That's in their original one. Plaintiffs' opposition ignores Weber, Shandwick, and Kaufman's arguments on the voluntary assumption of duty and makes no effort to distinguish the cases cited by Weber, Shandwick, and Kaufman. Instead, plaintiffs cite authority that is entirely inapposite and bears no resemblance to the facts of the case. Inapposite sounds like opposite and is pretty close to a whatchamacallit? A synonym. For opposite. Inapposite means inapplicable, not appropriate, bears no resemblance to the facts of this case. So first, plaintiffs rely on Landon v. Kroll Lab Specialists Incorporated and Bynum versus Kieber. And I talked about this in the previous video to establish a voluntary assumption of duty. Bynum is not even a voluntary assumption of a duty case. The defendant's duty arose from its ownership of the property where the plaintiff was physically injured. Good job, Landau. Good job. Let's see. Landon is similarly inapplicable. In that case, the Court of Appeals determined that the defendant drug testing laboratory owed a duty to plaintiff, an individual whose specimen was submitted to the defendant as part of his probation, to analyze his drug test consistent with relevant professional standards. Oh, excuse me. The court held that even though there was no contractual relationship between plaintiff and defendant, the contract was with the county, the defendant owed plaintiff a duty of care because the defendant actually conducted the test on plaintiff's specimen and released an inaccurate report resulting in significant harm to plaintiff in his probation proceeding. Unlike the drug testing laboratory, which undertook specific actions for the benefit of the plaintiff himself, Weber, Shandwick, and Kaufman undertook no action on behalf of or for the benefit of the plaintiffs. And it's important to note one other distinction here. Like, the drug testing laboratory's job is to test the specimens for the presence of drugs. That's the whole point. So providing an inaccurate test results violates the entire purpose for which the sample was being sent to them. Weber Shandwick's job has nothing to do with Maddox. Nothing to do with Maddox at all. No one hired Weber Shandwick on behalf of Maddox, as would be the case in the drug testing company, where the probation, the city, I suppose, would hire the drug testing company for the purposes of testing their probation subjects. And then, if they fail in their performance on that contract, it causes damage. That hasn't happened here. There's no hiring that took place that involves Maddox. This is completely out of everything. Okay. Weber, Shandwick, and Kaufman undertook no action on behalf of or for the benefit of the plaintiffs. Heather did not request that Weber, Shandwick, or Kaufman take any action at all to protect her, and she did not identify or even refer to plaintiffs in her emails. And Powell Stroud only asserts that he contacted Kaufman and discussed Kokonos' supposed harassment of Powell Stroud, not either of the plaintiffs. Because there are no allegations in the complaint or in the belated Powell Stroud affidavit that Weber, Shandwick, or Kaufman took any actions on behalf of or for the benefit of plaintiffs, the complaint fails to state any voluntary assumption of duties to the plaintiffs. Second, plaintiffs cite various data breach cases. Because nothing like collecting private data from people and having a breach due to your negligence, that is directly comparable to what has happened here. But in those cases, unlike the case here, the defendants had possession of the plaintiff's confidential information and agreed to keep such information private. See in our Experian data breach litigation. Defendant stored plaintiff's personal and confidential data on its servers. Abdale versus North Shore Long Island Jewish Health Systems Incorporated. Plaintiffs gave their personal information to the treating facilities in order to receive medical treatment, and that these facilities informed the plaintiffs that their personal information would not be disclosed to third parties without their consent. Lipes versus Atlantic Bank of New York. Defendant bank had duty to its own customers to maintain adequate controls to assure compliance with its own banking rules, and there's a footnote on that one. Plaintiffs miscite Farrow versus Excelis Health Plan Incorporated. The cited authority does not address duty, but instead discusses the fairly traceable element of causation with respect to plaintiffs standing in the data breach contract context. Don't do that. Make sure your citations are appropriate to the case. This is basic stuff. Here, the complaint does not allege that Weber, Shandwick, or Kaufman possess any confidential information of plaintiffs or promise to keep any information confidential. In fact, Weber, Shandwick, and Kaufman did not even know the identities of plaintiffs until the filing of the complaint, which is the first time they identified themselves. And that, again, is important because Landau is trying to sneak in this little dance where, Weber, Shandwick, and Kaufman told Asterios all about this, so we weren't lying to anybody. They were lying to Weber Shandwick. Even in the complaint, they're lying to Weber Shandwick because Weber Shandwick just knows the identities of the plaintiffs, but they don't know that Heather is Maddox. At least we don't have any information to suggest that they would. Gats asks, do you think Maddox, as sad as lawyer, is better at making people laugh online than he is? I hope this ends in him suing for being more funny than him. Quite possible. It is absurd to argue that Weber, Shandwick, and Kaufman had a duty to protect information regarding plaintiffs when there is no allegation that Weber, Shandwick, or Kaufman possessed that information or agreed to keep it confidential. But absurd arguments are kind of par for the course for Landau, aren't they? And Maddox, to be fair. Finally, for the reasons set forth in Weber, Shandwick, and Kaufman's initial memorandum of law, plaintiffs' reliance on public representations made by Weber, Shandwick concerning, quote, online harassment and trolling to establish duty is a classic red herring. Plaintiffs entirely ignore Weber, Shandwick, and Kaufman's argument on this issue, which demonstrates that the cited, quote, representations contradict plaintiffs' position because Weber, Shandwick's statements are directed clearly at protecting companies, not individuals such as plaintiffs. Weber, Shandwick, in this case, would be protecting Weber, Shandwick, not Maddox. You idiot. Instead, plaintiffs repeat the allegations made in the complaint and state without any support in fact or law that the company's public representations, quote, define the scope of its duty to plaintiffs. Moreover, the cited material merely analyzes the state of civility on the internet. The materials do not, however, establish any legal standards or practices for internet use or otherwise create a specific duty owed to plaintiffs. Plaintiffs' baseless arguments have no merit. Next, the complaint does not allege that Weber, Shandwick, or Kaufman acted without reasonable care. Even assuming, arguendo, for the sake of argument, that Weber, Shandwick, and Kaufman owed a duty to plaintiffs, which they did not, plaintiffs' negligence claims fail because the complaint does not adequately allege that Weber, Shandwick, or Kaufman acted without reasonable care in breach of that duty. Plaintiffs ignore Weber, Shandwick, and Kaufman's arguments on the elements of negligence. On this element of negligence. Plaintiffs cite no authority to support their claims, nor do they attempt to explain why the actions taken by Weber, Shandwick, and Kaufman in response to communications from Ozunian, falsely posing as Heather and Powell Stroud, were unreasonable. Instead, plaintiffs merely state the bare, some would say bald, legal conclusion, again, without any supporting facts, that Weber, Shandwick, and Kaufman, quote, failed to exercise reasonable care. Those allegations are insufficient as a matter of law, and plaintiffs therefore have failed to allege a necessary element of their claims. Because, and again, this is reasonable, legal conclusions. Legal conclusions cannot be upheld by the court without a factual basis to come to the legal conclusion. If you don't have the facts, you can't make the conclusion. The court's duty is to ignore it. So this is just Munoz reminding the court that they have to ignore that stuff. The complaint does not allege that Weber, Shandwick, or Kaufman caused plaintiffs injuries. This is important. The breach of duty has to be the proximate cause of injuries. Not just a but-for cause. It has to be the proximate cause. Proximate cause means it is the most recent intervening cause. So, again, if you're driving at all and you get in an accident, your driving is a but-for cause of the accident. If you weren't driving, there would not have been an accident. But someone else running a stop sign and ramming into you when you properly are observing the traffic rules, that becomes the proximate cause of the accident. Okay? So that's a way to kind of think of that. And a but is for pooping, silly. For the reasons set forth in Weber, Shandwick, and Kaufman's initial memorandum, plaintiffs' negligence claims must also be dismissed for the separate and independent reason that the complaint fails to allege the necessary element of causation. In response, plaintiffs merely state that Kokonos' alleged malfeasance was foreseeable and plaintiffs' damages were caused, in quotes, by Weber, Shandwick's conduct. But plaintiffs do not point to any factual allegations in support of those... They left out an of! No of! In support of those conclusory statements of law, because no such facts exist. The causes cited by plaintiffs to establish causation are readily, or the cases cited by plaintiffs to establish causation are readily distinguishable again. And we have a footnote. The plaintiffs cite these, The plaintiffs cite these causation cases only in their discussion of the negligent retention and supervision claims, yet the causation element is required for all negligence-based claims, and therefore the analysis is applicable to all of plaintiffs' causes of action. All right. In Gonzalez versus City of New York, plaintiff's estate sued the police department for negligent retention and supervision of a police officer with violent propensities who fatally shot his girlfriend with his police-issued gun while off duty. The court noted that to establish causation, the plaintiff must demonstrate, quote, a connection or nexus between the plaintiff's injuries and the defendant's malfeasance. In reversing the lower court's decision, the First Department held that the plaintiffs established the requisite nexus because the police department played a role in, quote, both creating the danger by training and arming an officer and rendering the public more vulnerable to danger by allowing him to retain his weapon and ammunition after it allegedly learned of his dangerous propensities. The other cited cases are similarly distinguishable. See Morand versus City of New York. School had a duty to protect students from assault. Its complete lack of security after receiving express notice of a student's intention to kill the plaintiffs could constitute proximate causation of the plaintiff's injuries resulting from the student's subsequent assault. See also Cursor versus G4S Solutions, Inc., upholding denial of motion to dismiss where an employee of defendant assaulted the plaintiff, a customer of defendant, on defendant's property. Here, plaintiffs not only failed to allege a duty, but plaintiffs failed to allege any specific nexus between Weber, Shandwick, and Kaufman's handling of Azunian and Powell Stroud's complaint in February 2017 and the alleged harassment campaign forged by Herrera and the other defendants in their resulting injuries. Even if Kokonos used Weber Shandwick's technology to access the internet for his alleged offenses, which Weber, Shandwick, and Kaufman do not concede, the complaint does not and cannot allege that Weber Shandwick's technology, quote, created the danger in the same manner as arming a police officer with a loaded gun. Further, the plaintiffs do not allege that Kokonos could not and did not access the internet through other means, and any such allegation would be absurd. Because he could use his phone. He could use a coffee shop. He could use anything other than Weber Shandwick to access the internet. And the idea that he solely used Weber Shandwick's technology would be completely ridiculous. The complaint therefore fails to allege a sufficient causal connection between Weber, Shandwick, and Kaufman's alleged conduct and plaintiff's injuries. Plaintiff's negligence claims fail for lack of causation. The negligent hiring, retention, and supervision claims should be dismissed. Plaintiffs make several arguments specific to the negligent hiring, retention, and supervision claims. First, they argue that they properly state those claims against Weber, Shandwick, and Kaufman because Weber, Shandwick, and Kaufman were on, quote, notice of Kokonos' quote, violent propensities. Notice the lack of violence coming off of Kokonos in all of this. In February 2017, and as a result, Weber, Shandwick, and Kaufman had a duty to, quote, initiate an investigation into Kokonos and or, quote, terminate his employment or at the very least ban him from further use of Weber, Shandwick's technology and equipment. Plaintiff's claim fails as a matter of law. And this is becoming a mantra right now. As discussed in Weber, Shandwick, and Kaufman's initial memorandum, plaintiff's allegation that the vague and anonymous communications from Heather/Azunian and now Powell Stroud put Weber, Shandwick, and Kaufman on notice of Kokonos' violent tendencies is not credible. So the allegation is not credible. That was kind of a long sentence if you didn't get the connection from the subject and the predicate. In those communications, Heather/Azunian claimed Kokonos was taking part in an quote, online harassment and bullying campaign, but included links to statements regarding rape made by defendant Dax Herrera, not Kokonos. These communications do not state in any way that Kokonos has a propensity for violence, nor do those statements state in any way that Herrera has a propensity for violence. Let's just throw that out there for them. It's not Weber Shandwick's duty to defend Dax Herrera in any way, of course. But let's be honest, none of the statements hold up this idea that there's a propensity for violence. Although, I'm just guessing, but I would imagine that Maddox and Powell Stroud are probably the least capable people of violence on the planet or close to it. With a slightly more capable person being Jess, who I imagine is dominant in all of this. Next, plaintiffs contend that their claims do not depend on whether Kokonos acted within the scope of his employment and that Weber, Shandwick, and Kaufman had a duty to police the out-of-work private online activities of Kokonos based on the alleged, quote, notice in February 2017. Weber, Shandwick, and Kaufman do not argue that an employee must be acting within the scope of his employment in order to establish claims of negligent retention, supervising, or hiring. Rather, Weber, Shandwick, and Kaufman point to authority establishing that a duty to police an employee's private interest activity is far too amorphous and overbroad to be recognized under law. Absolutely. Plaintiffs offer no authority to the contrary. In fact, the cases cited by plaintiffs are entirely inapposite because in each case, unlike here, the defendant employer had a clear duty to the plaintiff and the employer affirmatively placed the employee in a position to commit the tort. C. Gonzalez. Defendant police department trained an armed police officer with a gun and failed to take the gun away after knowledge of his dangerous propensities. Now, I'm going to be a little critical here. To say that they put the police officer in a position to commit the tort in this case is a little bit of a stretch in my opinion. But I think it's fine. But if I'm being fair, I would criticize that characterization of that citation. So next is Crystal G. versus Roman Catholic Diocese of Brooklyn. After school officials tried to remove priests from the church school based on inappropriate conduct with students. Defendant supervisor allowed priest to continue in his role at the church school where he later sexually assaulted plaintiff student. That one's a little more clear. See also Baez versus JetBlue Airways. Customer of defendant airline brought claims against airline and its employee for injuries sustained while at airline terminal. So that's being on the defendant's property, and that of course changes the entire calculation. None of these cases support the contention that Weber, Shandwick, or Kaufman had a duty to monitor and regulate Kokonos' alleged private internet activity. Ionic Paul says Shandwick is doing a Asterio/Dick a solid by not conceding that they are guilty of the allegations. In a roundabout way, but they're doing themselves a solid. Because if they concede that they're guilty of these allegations, then all that Maddox has to do is establish duty, and then they're on the hook for it, right? So by not conceding it, it's that extra step. First, even if you get past duty, breach, damage, you have to show that, or duty and breach, you have to show that there's this last part where they're actually guilty of these allegations, where these allegations are part of that, and our duty then makes us culpable. So no, they're not giving any ground, and they're doing a slight solid, but it's in their own interest to do so. Okay, none of these cases support the contention that Weber, Shandwick, or Kaufman had a duty to monitor and regulate Kokonos' alleged private internet activity. Lastly, plaintiffs further incorrectly characterize Weber, Shandwick, and Kaufman's argument by contending that Weber, Shandwick, and Kaufman argue that alleged tortious conduct must be committed within the defendant employer's chattels or on the defendant's property in order to state a claim for negligent hiring, supervision, or retention. Weber, Shandwick, and Kaufman do not make that argument. Instead, Weber, Shandwick, and Kaufman cited D'Amico versus Christie and Palka versus Service Master Management Services Corporation to show that courts, including the Court of Appeals, have warned against exactly what plaintiffs seek here: the imposition of an enormous, amorphous duty on employers to protect all members of society from any actions taken by employees anywhere in the world. Plaintiffs seek to tie Kokonos' alleged harassment to Weber, Shandwick, alleging that Kokonos used Weber, Shandwick's equipment and technology. Plaintiffs' speculative and conclusory allegations of Kokonos' use of Weber, Shandwick's technology and equipment fall short because the complaint does not allege that such use directly caused the plaintiff's injury. See Doe versus Federal Express Corporation. Dismissing negligent supervision claim where defendants' chattels, goodwill, telephone, and uniform were not, quote, directly involved in causing the sexual abuse of plaintiff. The complaint alleged that Kokonos harassed plaintiff over the internet and by recording a digital album insulting plaintiffs, actions he could have taken through any number or personal or publicly available resources, i.e. any computer or cell phone capable of recording sound and sending it over the internet. The alleged use of Weber, Shandwick's equipment with no supporting allegations does not tie Weber, Shandwick to Kokonos' alleged activity in any legally cognizable matter. And idiots, you have an affidavit from Powell Stroud, the originator of the claim that Asterios used Weber, Shandwick's equipment. Why didn't you include it? Maybe you don't have that factual information and you don't want to lie under oath again. Maybe that's why. I don't know. But you have a guy who routinely chest thumps that he saw the thing where Asterios was using Weber, Shandwick's equipment, and then you have an affidavit from him and you don't include it. That's something that might have gotten in. Might have say, actually, we didn't know that he knew this, but now he does know it. I don't know. You got to try. Anyway. For these reasons and those set forth in Weber, Shandwick, and Kaufman's initial memorandum, the plaintiff's claim for negligent supervision, retention, and hiring should be dismissed against Weber, Shandwick, and Kaufman. The negligent infliction of emotional distress claim should be dismissed. Yeah. I mean, I almost wish these argument sections ended just with their titles. Just with their titles. Plaintiffs argue their negligent infliction of emotional distress claim survives because 1, extreme and outrageous conduct is not an essential element of the cause of action. Well, that's interesting. And 2, emotional harm is compensable even though no physical injury occurred. Plaintiffs' arguments fail as a matter of law and ignore the fatal flaws in plaintiff's claim. Hyperion 9997, Ballantyne's is really good for cheap scotch. Thanks, man. I've heard Ballantyne's is really good. I also have a friend with the last name of Ballantine, so I will ask him if it's good. I think he likes scotch as well. But I'll check it out. As discussed in Weber, Shandwick, and Kaufman's moving memorandum, to state a claim for negligent infliction of emotional distress, a complaint must allege 1, an emotional injury, 2, from defendant's breach of a duty, 3, which unreasonably endangered plaintiff's own physical safety or causes the plaintiff to fear for his or her own safety. Sheila C. versus Povich, Kenneth S. versus Berkshire Farm Center and Services for Youth. The plaintiff's claim fails because the complaint fails to allege any duty of care owed by Weber, Shandwick, or Kaufman, and fails to allege Weber, Shandwick, and Kaufman acted without reasonable care in breach of that duty. Footnote, plaintiffs argue that Orenstein versus New York City Health and Hospice Corporation creates an exception to the direct duty theory by recognizing that a duty specific to a targeted group of individuals is sufficient to establish a direct duty to Blum. Orenstein makes no such holding. In Orenstein, there was no question that the defendant hospital and employee owed a duty of care to the plaintiff, who, unlike the plaintiffs in this case, was an employee of the defendant hospital and injured while on the premises. Oh my goodness. The authority cited by Weber, Shandwick, and Kaufman establishes that, quote, extreme and outrageous conduct is required to state a claim for negligent infliction of emotional distress in the first department. Plaintiffs rely on a second department case, Taggart v. Costabile, to eliminate this element of the claim. Yet Taggart is not binding on this court. The First Department has not adopted Taggart's elimination of the extreme and outrageous conduct component of a claim for negligent infliction of emotional distress or applied its holding on this issue. In fact, a 2016 First Department case decided after Taggart and cited by plaintiffs on page 18 in the opposition, Kurzer versus G4S Government Solutions Incorporated, expressly contradicts plaintiff's position. Kerzner upholds the dismissal of a claim for negligent infliction of emotional distress because, among other reasons, the claim did not adequately allege extreme and outrageous conduct. Accordingly, the 12th cause of action should be dismissed because a complaint fails to allege any extreme or outrageous conduct sufficient to sustain a claim for negligent infliction of emotional distress. So here is the danger of citations, especially in a forum like New York. You have, we'll use the U.S. as an example. Real quick, Pepe Frosch, would audit logs of Asterios' Weber Shandwick computer activity come out in e-discovery if the case is not dismissed, and why will it mostly be mostly hentai? Well, I think Waifu Wars is evidence that Asterios is low-key into hentai, and whether or not it would come out in e-discovery would be if they could sufficiently convince the court that it should come out in discovery, if they could sufficiently and narrowly tailor their request for the documents to make it reasonable to request them, and if they could convince the court that it is worth overriding any business interest Weber Shandwick may have in those documents. It's possible. It's possible. But there is an argument. There's an argument there to be made for sure. Garrett Davis, shouldn't you move this stream to Pornhub? Seems appropriate when covering how hard Maddox is getting pounded. I don't want to do that. I really don't. It's funny And Pornhub is hilarious, and props to them for taking on content that other people will not. I hope to not have to do that, because I'm a family man. I don't want my videos on a pornography website if I can avoid it. As funny as it would be. So going back to this, so let's talk about the United States as a whole. You have various circuits for appeals. Like the Ninth Circuit obviously is famous, West Coast Circuit, and includes Hawaii. You have the Fourth Circuit, 1 through 12, I think 13. I don't even know. I don't care. Each of the different circuits has different rules, and when you're citing to a case in that circuit, you better cite to a case from that circuit. If you're not citing to a case from that circuit, unless it's from the Supreme Court of the United States, it is not authoritative. It can be advisory, it can be informative, it can be persuasive, but it cannot bind the court to its decision, and you must clarify that it's not an authoritative decision, that it doesn't bind the court, but the court should adopt it for various reasons, like public policy or to get with the times, you idiots, or whatever it is. But you have to do that. And if you don't do that, it looks like you're misrepresenting to the court the authority of the case. And the court's going to find out because they're going to look at your citations. So as here, they're citing to the second department, not the first department, while this case is in the first department, and the second department has made a ruling in Taggart that the first department has refused to adopt so far, so it is not binding. All right. Gatscat says Rackets prefers Spank Bank confirmed. Weber, Shandwick, and Kaufman do not argue that a physical injury must occur in order to sustain a claim for negligent infliction of emotional distress. Rather, Weber, Shandwick, and Kaufman argue that, consistent with the case law, the defendant's breach of duty must, quote, unreasonably endanger plaintiff's own physical safety or cause the plaintiff to fear for his or her own physical safety, citing Kenneth. More importantly, however, the resulting injury must be a, quote, direct rather than consequential result of defendant's conduct. The complaint does not allege any conduct on behalf of Weber, Shandwick, or Kaufman that directly caused plaintiff's alleged injuries. Infliction of emotional distress is tough. It's a tough claim, and we're talking about real trauma, not just being made fun of. I don't know how else to say it. And that's intentional infliction of emotional distress. Negligent is even tougher. It usually involves a drunk driver running over someone's child in front of them, or they have a duty of care to pedestrians on the road. They're drinking in violation of that duty. It causes them to run over a kid. That kid, it puts the plaintiff in danger because they're close to the kid and they fear for their own safety, or in some cases the safety of a loved one. I don't know if that's a first department standard or not, but it is in in Minnesota. So yeah, that's the type of stuff that negligent infliction is reserved for. Not, he made fun of me, my feelings are hurt. Gross. The cases cited by plaintiffs are entirely inapt because, unlike here, those cases involve a duty owed from the defendant to plaintiff, and the defendant's actions directly cause the injuries. In Kennedy versus McKesson Company, a dentist sued alleging the defendant had negligently repaired an anesthetic machine, resulting in a patient's death. A wrongful death action ensued against the dentist. In determining whether emotional damages were recoverable, the Court of Appeals held that plaintiff could recover for the harm to his professional reputation, but not for alleged emotional damage because, quote, there is no duty to protect from emotional injury a bystander to whom there is no otherwise owed no duty. Similarly, inapposite is Johnson versus State of New York, where the Court of Appeals found the defendant hospital negligently inflicted emotional distress on patient's family by mistakenly informing the plaintiff daughter that her mother was dead and causing her to incur funeral expenses and emotional injuries. Funeral expenses! So it's not your mother's dead and then an hour later, oh, sorry, we got that wrong. Oops. She went out and planned a funeral and bought it. She bought a funeral for her dead, still living mother. In that case, the defendant hospital had a duty of care to its patients and their families to properly advise the family in the event of death of a patient, and the incorrect information delivered to plaintiff directly caused her injury. That's stunning. Neither Kennedy nor Johnson support plaintiff's claim for emotional damages. Rather, they support dismissal of plaintiff's claim because plaintiffs have not alleged 1. Any duty owed to them by Weber, Shandwick, or Kaufman, or 2. Any actions by Weber, Shandwick, or Kaufman that directly caused plaintiff's alleged injuries. For these reasons, the plaintiff's claim for negligent infliction of emotional distress should be dismissed. Pardon me, I had to sneeze. Sorry about that. The claims against Weber, Shandwick, and Kaufman must be dismissed if the claims against Kokkinos are dismissed. The claims against Weber, Shandwick, and Kaufman must be dismissed if the court dismisses the complaint's direct claims against Kokkinos, because the claims against Weber, Shandwick, and Kaufman arise directly from Kokkinos' alleged tortious conduct. So that's just one more round, and especially because Asterios' motion is being heard first. Conclusion. For the foregoing reasons, and the reasons stated in the opening brief of Weber, Shandwick, and Kaufman, the court should dismiss the complaint in its entirety and with prejudice against defendants Weber, Shandwick, and Kaufman, and grant Weber, Shandwick, and Kaufman such other and further relief as the court deems just and proper. And we know they are about to ask for a lot more when they file their motion for sanctions, which will include attorney's fees in the action for the repeated lies and misrepresentations by Maddox and crew. Lies and misrepresentations brought to you by the Madcast Media Network. Definitely fake news. So, there we are, guys. 18 total pages, 14 pages of argument. I open the floor to you. I will answer questions for a little bit, but I must admit that I do have a little bit of a headache from this cold. So we're not going to stay on too long tonight. Plus, we're at a cool hour and 12 minutes right now. And dragging it out much longer than that will get a little ridiculous. Especially because we're likely going to see another document drop from Munoz very soon when they file sanctions. And we may have some more information in the lawsuit coming up soon. So, Caleb Segura says, my wife says she likes your whiskey shelves. We all know it's a cover. It's a cover. Yeah, it is a cover. If you notice, there's a bunch of nerdy Warhammer 40k books behind the whiskey. So it is a cover. Absolutely. I know this is so stupid. When will they decide? I don't know. First, there has to be a motion hearing date. Then they have to have the motion hearing. Then they probably have up to a month to decide. They may decide at the date, but judges can take extra time, and we won't know until they actually do it. But as soon as we have some information on what is happening, I will relay that here. Is there any action any of the defendants or lawyers has taken that you disagree with or you think hurts their case? I don't know that there's any that specifically hurts their case. There are some actions where I would have come out a little more aggressively in light of who the plaintiff is and how they have conducted themselves. Greenberger and Munoz have filed the motions for sanctions. Everyone should at this point file the motions for sanctions, in my opinion, and they should be going a little more aggressively after fees for the frivolity of the suit. Would you recommend your kids to the lawyering profession if they want to do it? Honestly, I know the meme, right, is that there's grizzled old lawyers everywhere saying, don't do it, it's terrible, and then they, drive home in their Jaguar or Lamborghini or whatever. No, if you want to do it, do it. If you want to learn a bunch of pointless stuff with the possibility of helping people do things, do it. If you want to make a bunch of money, do personal injury in a huge venue with lots of injuries. There's different types of law work for whatever you want to do. If you want to do it, do it. I'd recommend it to my kids if they want to do it. If they don't want to do it, no. No. Don't do it because I did it. But that'd be my advice on anything. Do lawyers change more if they have to work while under the weather? Charge more? Yes, probably. Does Asterios still have a court date of April 7th? Will his suit be decided first, pending no delays? I have no idea on what the court calendar is right now. I'm going to try and find that information and post it somewhere. Gary M. asks, in all honesty, how likely is it that Maddox has a chance to win this? I don't want him to, but I'm scared after Dankula. It's possible. It is possible to win because it's always possible to win in court. But I would suggest that the odds are very low. You know, looking at this, especially with the misrepresentations to the court, it's very low. Very low. Check out the YouTube video Cool Court by Sick Animation. Will do. Are we aware of what reason this was bumped for? I'm not aware of any specific reason. The way these things go, guys, you have government, and government is terrible at everything it does. So they probably just rescheduled it because they probably double booked, frankly. That's it. Although it is possible, my other speculation, if it's not just double booking and some sort of scheduling conflict, or maybe Ramos wanted to go play golf or something, who knows, if there is a reason for it being bumped, then I would say it's because they want to hear the sanction motions before they hear the motions to dismiss, because the sanction motions have more oomph to the outcome. Gats, how long would one have to study bird law to be as good as Landwy? Landwy riding his bike to court, gfycat.com/fluffy vein hypocrosaurus. Hippocrosaurus. Okay, got it. I would say that the average person is probably about as good at law as Kevin Landau at this point. Okay. Give a brief reason why you suspect the decisions today may have been postponed. I think I just did that. It's either just court calendar issue or they want to hear the sanction motions first. My wife is now angry that I used her for a shout out. Cheers. You're welcome. Causing marital unrest. One video at a time. What is the only way Maddox can walk away from this unscathed, if there is one? You know, he can walk away from it. Well, he can't walk away. The only way to walk away unscathed is if he wins. If he wins and doesn't have to pay Landau. Or doesn't have to pay Landau more than he's awarded. That's how he walks away unscathed. Otherwise, I mean, his bill is going to be monstrous. Monstrous. If Maddox won, who would pay the 20 mil exactly? Likely, the way it's written, let's say the court just accepted the arguments of everyone and just ruled on the complaint as if it were 100% true, then everyone would be jointly and severally liable for the payment. So everybody would be paying $20 million. Everybody would be responsible, and the individuals may have various claims against other individuals. It's a mess. It's a mess. They don't allege that the individual breakdown of damage. The court may decide that, but they might just make everybody jointly and severally liable. Just Maddox gets paid $20 million. You guys figure it out. How many super chats until you can afford another bookshelf to fill out the background? I can't put another bookshelf there because there's a window, and I don't want to put a bookshelf in front of a window. So, sorry about that. From the previous stream, does the real Heather S. have a case against Maddox for using her ID? If she should choose, probably not. She's not really victimized in any way. I know someone suggested that maybe subjecting her to a mob of angry internet personalities as a result of it may cause that, but we don't have any evidence that she's been bothered by anyone, so I don't want to go ahead and say that she has a case. Probably not. If Maddox actually won, who would pay the $20 million exactly? I think I just said that. Say the suit held for Asterios and Weber Shandwick and failed for everyone else. Would the burden be split between Asterios and Weber Shandwick? Yes. Yes. And they would each be 100% liable with a presumption of 50-50, but it would have to get paid first, and then someone would have to go after the other one. Justin Brodak says, I think Landwy will sue Heather S. next. Yeah, it's very possible that he could, because I think Heather S. might not be able to pay Landwy the astronomical fee that he's got to be charging for this. Remember, the motion to dismiss or default judgment against Asterios allegedly cost $2,500. We know that the filing the motion for sanctions cost allegedly $7,500. That's $10,000 for two tiny aspects of this case. On a further note, the Landau Group's fees are absurd. Will you do Costanza versus Seinfeld soon? I would like to. I just need the time to do it. Have you addressed the major differences between a commercial trial and a jury trial, or is it just the lack of a jury? I have not addressed the major differences. I don't know. I don't know if there's a lack of a jury in commercial court. There may be, but I think that there's still a jury involved. It's just that the court expedites sort of the pre-trial process and the exhibits that are allowed. I think a jury still exists in these cases once you get past the matters of law and into matters of fact. But the commercial court would specialize in those matters of law. Why would Maddox be exempt from this lawsuit simply from not being served? Because there's a 120-day rule. If you don't serve within 120 days, game over. What if all legal arguments had to be presented on anonymous image boards? I want memes and smug anime girls with my filings. Absolutely. That's a great reform. You should do a video of Landwee's top legal blunders. That is in the works. That's just a big video. So you're in Minnesota and have given Canada a lot of crap in these videos, but you know we consider you guys Manitoba South A. I do know that, but I am from Texas, so that's where it goes. Tess, is JPS going to get pulled into this? Can we see his smug face get pummeled in conspiracy? I doubt it. In Discovery, will they discover Maddox is a cuck? Absolutely. If they don't know it already, it will be. Apparently, Greenberger intends to prove in court that Maddox is a cuck, and hopefully the judge is not so intrigued by that he just rolls with it and brings them all in for that. Fuzz Got Games, I read and really enjoyed Ilium. Thanks for the recommendation. Absolutely. Make sure you follow it up with Olympus. Thank you for preventing my suicide by continuing to produce content. Anytime, Ben. More content is on the way. Do you think Courtney Love pulled the trigger? Dude, I do. I do. I have nothing to back it up. I do. Whoa. Got to catch up here. Sorry about this. My chat just scrolled way down. Do shotgun approaches, tons of allegations like Landwee's complaint ever work with regularity? Yeah, you do. You always go ahead and throw every potential claim up. Even if it's weak, you throw it up there. I think they added claims that are a bit beyond that, but if you have any potentiality of a claim, you should put it there. But that you should have potential for a claim. Like I said, I think they went too far in this case. But yes, occasionally you get the stuff. And if you want a great example of this happening, like at the highest level, look at the Patient Protection Affordable Care Act, more commonly known as Obamacare. The idea that it is a tax under the tax and spend power was barely asserted by anybody. In fact, they had to hire a lawyer to specifically come in because none of the parties wanted to argue that, and that's the way it was upheld. So yes, those shotgun approaches do occasionally work, even at the highest levels. Can Landwehr be disbarred from the Bar Association just looking at the details of this case and a reasonable person saying this dude is bat poop insane? Yeah, I think it would more be his misrepresentations to the court in this and in Almasiga. It's a GIF. I assume you mean in your super chat. I'll have to look at it later. Have you ever been on the wrong side of a court case? Defendant. I'm on the defendant side of court cases pretty frequently. I don't know exactly what you mean by that. Give us a David Hogg hot take. What do you have to say? Okay, so this is what's ticking me off right now about these kids in Parkland. They went through trauma. Absolutely. Arguably, some went through more trauma than others, but that's okay. That's okay. And that's a shame that they had to go through that trauma. However, that trauma doesn't give them any sort of special knowledge on morality or any sort of special knowledge on the Second Amendment or the issues around gun regulation and gun ownership in the United States. More importantly, all of these kids are teenagers, and that doesn't mean we should dismiss them. But when they say things like, you didn't know this kid, this is what we ostracized him because of who he was. You didn't know him, we did. Look, we all knew him. We all went to school with that guy. Some people may have been that guy. I made a Facebook post about this, but like the idea that there's some new thing that, all of you old people never experienced anything like that. Of course we did. Of course everybody does. You're not new. It's a fallacy of primacy in which you think that your circumstances are somehow unique or different to everyone else's, and it's never been done before in the history of the United States or the history of the world, and that's just nonsense. But they're teenagers, right? Like this is why we don't listen to teenagers, because they don't possess the logical or reasoning background to get to making cogent arguments. I will do a video telling folks how to assert their rights when being pulled over. I am hoping to rope in either a cop or a former cop to do this. That is pending. Have you Lawsplained why commercial court is special yet? I think I did very early on. Thank you for being the most entertaining lawyer on YouTube. You make lawyers less scary. Thanks, I really appreciate that. How likely is Landwy to be sanctioned? Can he be reported to the Bar Association? I think at this point it's a good possibility that he is sanctioned. We'll see what Weber Shandwick's sanction motion says, but I mean it's got to be at this point. And can he be reported to the Bar Association? Yes, but who does that is the real question. And Dax Desi agrees that I am the most entertaining. Thank you. You ever find any court documents regarding the motorcycle track day crash I linked to you a week or so ago? Not yet. Do you think Landau is working on a if I win you pay kind of agreement? I think there's a contingency in there, but I think there's also a retainer fee that's been paid and probably some ongoing expenses because these are expensive cases. And look, think about it this way. The Landau group, if they were not doing this case, potentially could be doing another case worth $50,000. They're not going to just say, whoa, we're going to do everything. We're going to run this extremely expensive case against these massive companies solely on contingency. And if they know anything, they would know that their claims are weak. So I'm sure they do have a high contingency fee as well as an hourly fee. What's going on? Do you think the money Maddox got for fast risk whales will even come close to covering legal fees? I doubt it. Why would Magcucks be exempt for this case if he wasn't served? Is the assumption that they should just serve him in a separate lawsuit? No, it will be dismissed. He'll be exempt from this case, and it will be dismissed with prejudice. They won't be able to raise these issues against him again. They should have served him in this lawsuit. They didn't. That's their fault. Motorcycle track day. Whoa, you're Texan what? Yeah, I was born in Houston, Texas, buddy. Lived in Inwood Forest Village, which was right by Acres Homes. If you know where that is, it's the quarter of West Gulf Bank and Antoine. So, or Little York. Little York's over there too. Yeah, man. Good part of town. As if you know much about Houston, you'll know that was a good part of town. Do you have any good court stories you'd like to share? I do share some court stories on Real Law Stories, which is bonus content on Patreon, and I may do some videos ahead of in the future about them, but I haven't gotten them. My birthday is on Easter. What should you do for it? You should definitely pray and respect that Jesus died for your sins. We should do a dickhead mock court where you're judge and you hear our cases and I say we start with Dick's toilet. That sounds great. Should Landwy be disbarred and banned from all bars as well? Probably, for his own safety. Who has a smaller chin, David Hawk or Leafy? That dude's face is shockingly angular. My Asian buddy, thank you, Kellen Miller, lives in France and was described... that can't be real, right? Lives in France and was describing the adversarial system of law they have. You should do a video on it. It's terrifying. Yeah, I could and talk about how that's kind of how the Louisiana courts go. I'm a sovereign citizen. Explain how I'm right. No one can explain how you're right. Mossberg 590 or Remington 870. Also blood for the blood god. I don't know. I'm not a gun expert. I don't want to claim to be one in any sort of way. And I have not fired either of those. When he wants to prove that Maddox is a cuck in court of law, is a statement like that common in lawyer speak, or is that extra layer of threat, public humiliation, and intended bonus? That's a bonus. So glad to hear you make the same argument as me about those kids. I thought I was going mad. No, you're not. Everybody else is. I bought some disgusting Fireball to celebrate Maddox's loss, but looks like I have to open up this will to try to enjoy. Sorry, buddy. I have not opened my little tiny bottle. I don't even know where it is right now. It might be in my kitchen. Let's see. Will you please get a fuchsia suit for the next road rage? I'll have to see what I can do. If Maddox actually wins a lawsuit, it will mean that civil liberties are much further gone than we thought. Yes, no. Yes, certainly in the 1st District of New York. No, because I think it would get overturned on appeal. Hola, sir. Any updates on when you will collaborate with YouTuber Law? Not yet. I need to talk to him, and I am sorry. I'm just really, really busy. What if Jesus was aborted? Well, thank God he wasn't. Do you think Landog is pooping his pants right now, realizing he may be destroyed from this? I hope so. If this case doesn't get dismissed, goes into discovery, then Maddox loses. What is most likely to happen from there? The fees get, $100,000 higher. It's almost unfathomable to see what happens if this goes to discovery. Because it costs a fortune. They're going to have to do depositions on people in every state. I think Landau has to withdraw. Because Maddox there's no way Maddox will be able to afford it. I'm late, so it might have been asked before, but have you thought about Lawsplaining Count Dankula court case, or is UK law too different? I have thought about it, and I'm hoping to do a UK-friendly or a Euro-friendly live stream for it. So keep an eye out for that. I just need the time to do it. Inquisitorial system, my bad. That sounds ominous. How does it feel making Dick want God in his life? It feels great. # blessed. I like the term outrage porn star for the Hogster. David Ogg looks like an alien that came here to find the biggest bull to F whoever he gave a promise ring to. Ooh. Do you play any of the Fallout games? I have Fallout 3 and 4. I didn't play them much. I like the medieval fantasy setting more of Skyrim and Oblivion, and I played 3 a good amount. I like using hammers, and in 3 I got to make a hilarious sledgehammer, so that was good. I'm out in the hill country, but I did find myself drunk as hell in a House of Pies in Houston. Oh, dude. Which House of Pies? Was it the one on Antoine? Because I used to go there all the time as a kid. I hated going there as a kid. Now I want nothing more than to go there. Are you going to be at Road Rage Austin? I hope so. Dick, if you're listening, I really need you to nail down the details of Road Rage Austin so I can see if I can get plane tickets. What are the chances that Landwy is a Maddox superfan doing this for free? It's possible, but over under that Maddox faces criminal charges. I think it's just the nature of prosecution. I think it's unlikely. Even though I think he fits all of the elements perfectly, I think it's unlikely he faces criminal charges, but I hope to be wrong on that. I think if it goes to discovery that you and I will get dragged in because of our shenanigans, that would be great. I would love for Maddox to be forced to pay to haul me into court. Ever play fantasy or just play 40K? Necrons or beasts? I don't play either of the tabletops. I played Dawn of War a lot, years ago. I play Total War, Warhammer 1 and 2 now. I've seen your D3 gameplay videos. You played Path of Exile on Steam. I did for 10 minutes and then I stopped because I was still playing Diablo 3, but it is intriguing to me. And I think they've completely redone a lot since I tried last. Regarding Dankula and international law, could the UK attempt to extradite an American who posted Nazi pug? What if they were visiting the UK when they posted it? No to the second one, maybe to the first one. No to the first one, maybe to the second one. How do you discipline your kids? Do timeouts work? On occasion. on occasion. You know, you try a lot of different things for disciplining, and it's different for each kid. But timeouts do work. Taking away iPads is apparently devastating. I don't know. Try Fallout New Vegas, amazing story with actual choice. There are also cool melee perks. That sounds like my kind of game. You have a favorite LoLsuit video so far? No, I don't. I don't go back and watch them very often unless I'm looking for something specific. And I always am pretty critical of myself, so I try not to do that. Do you vape? No, I don't. Any chance Landwy is a Maddox buddy living in a similar, clinging on to former glory state of doing it for free? I don't know about the doing it for free part, mainly because he's part of a law firm that does seem to operate on massive fees. I think it's entirely possible that he is a Maddox buddy. They're similarly aged, and Landwy has a lot of things tying him to LA. So it's very possible that they have either a mutual friend or are specifically acquainted or connected, and that is how Maddox went ahead and picked him. Otherwise, I can't imagine choosing him as a lawyer. You said under for Maddox facing criminal charges. Why? It's just the way prosecution works. You know, coming from a case like this and handing over the details to a prosecutor, I just have a hard time. Plus, it's based on words. Words prosecution is tough to do. I don't know if they're going to do it with a busy court calendar and busy files. I hope they do. But it's just kind of it's not the legal aspect of it. It's just a practicality of prosecuting it. Makes me wonder. Thanks for the vids, bro. Got to hit the hay for work. Talk to you later. You too, nobody. Thank you for bringing an Odyssey reference into the stream. I really appreciate it. All right, guys. I'm gonna wrap it up here. Last two questions. I hope Maddox sues you for doing these videos so you can have a $20,000 Patreon. That'd be hilarious. I just Googled it. Looks like I was at the House of Pies on Westheimer. Anyway, I love your videos. I haven't been to that one, I don't think, but you know, next time I'm in Houston, maybe. What if sometime after this Landau Maddox comes to you for representation? Would you take their case? They'd have to really prove that they have some money. Because right now I doubt it. He admitted to being guilty, though. He completely admitted to guilt. I don't know. F. Maddox. Yeah, I agree. He completely admitted to it. And but there, real talk on those things, there are some minor mitigating factors. And just with the high bar of beyond any reasonable doubt, like the reasonable doubt is that he's clearly a stupid idiot. And that might be enough to get him off. I didn't know I was committing a crime. Any of that stuff. I think he is guilty personally based on what we've seen, but I have no faith in prosecutors doing the right thing. Sorry, Raph. Love your videos. Much love to you and your family. Wish you the best. Thanks, Gary. With that, guys, thank you so much for joining me. This has been Lawsplaining the Interwebs. Please check me out on, I'm going to get this right one time, patreon.com/Lawsplaining. At the top left of the screen, you can see the address. Go there, check me out. You can get audio of all this stuff. You can talk to me. I love to interact with the fans. Interact with me in the comments. Hit me up on Facebook and Twitter. Nothing I like more than discussing and arguing about stuff. David Bird, it was Ilium and Olympus by Dan Simmons. And I'll try and throw those in the chat in just a second so you can see them. If you get done reading Ilium and Olympus and you really like the Trojan War sort of vibe, there are 3 books by David Gemmell that are not sci-fi, but they are historical fantasy fiction. Not with magic and stuff like that, but just, I shouldn't say fantasy. They're historical fiction, and they're a great different sort of take on the Trojan War. And it's by David Gemmell, and it's Lord of the Silver Bow, Shield of Thunder, and Sword of Kings. And definitely check those out. Those are great if you like Greek, not mythology, but Greek literature and the Trojan War. If that's an interesting subject, they're really great books. Cool court, sick animation. Check it out. I will do so. All right, guys. Thanks so much for joining me. I'm going to blank out the screen, and as always, once it is blanked out, I'm going to end the video. Peace. Next live stream will be Friday. We do Friday live streams, and it will either have a LoLsuit subject or something else like Sovereign Citizens, so it should be fun. And yes, I play Vermintide 2 pretty regularly. I'm blanking it out, but I'll answer a couple questions till I see it go blank. Great stream. Glad you could catch it. Forgive me for having no good questions or funny comments. That's fine, Zev. No worries, buddy. Thanks for watching.